People versus Peters. Are you ready, counsel?
Ronna, good afternoon. My name's Eric Nelson. May it please the court. Ronna, may I reserve 5 minutes on rebuttal, please?
Yes.
Thank you. Ronna, this case is an appeal of a quorum nobis denial by the Second Department.
What is it the denial of the quorum nobis petition, or is it re-argument? What's before us?
Before Your Honor is the, this is the appeal of the denial of a quorum nobis proceeding.
And those claims that were raised in that original quorum nobis, is that what is before us?
The issue before the court, as specified by Chief Judge Wilson, is the issue of ineffective assistance of appellate counsel.
Okay. When you're seeking the review of quorum nobis, and you're saying the appellate division was wrong in the way that they decided, correct?
Correct.
And we can only review what they reviewed and made a decision on. Would you agree with that?
Not necessarily, Your Honor. I know the district attorney.
We can review things, we can consider that which was not considered by the appellate division and say they wrongly decided something that they did not in fact decide?
Your Honor.
Counsel, could you move a little to the center
Sorry,
here?
I'm
I
sorry,
think the
Your
mic
Honor.
will pick you up better.
My
Acoustics are a
apologies.
little difficult.
Your Honor, in the people, in the prosecution's brief, one of the issues that was raised before getting into the facts of the ineffective assistance of appellate counsel was whether or not this court had jurisdiction to hear the ineffective assistance of appellate counsel claim. The prosecution's claim, if I may, is that the Second Department should have heard the issue of the ineffective assistance of appellate counsel before bringing the proceeding in this court. In this court, Mr. Peters, the defendant, brought a pro se application before this court, and the chief judge granted leave.
But when I met, and just for clarification, what's brought here is different from what the appellate division heard.
Yes, yes, it is, Your Honor.
Okay.
In the appellate division, as Your Honor correctly points out, the claim of ineffective assistance of appellate counsel was not raised.
Okay.
My contention is, Your Honor, and I respectfully disagree with
Wait, why do you say that his original petition, quorum nobis petition, did not raise ineffective assistance of appellate counsel?
Because I believe, Your Honor, that it raised issues such as ineffective assistance of trial counsel. In the appellate division, Mr. Peters, in his pro se application, repeated many of the claims that were denied by the appellate division.
It seemed to me that the first thing, did you speak, well, were you aware that there was a conference with Mr. Peters and with Mr. Newbort and me?
Yes, I was, Your Honor. In fact, I've had numerous conversations with
Okay,
Mr.
good.
Newbort, and when I first was assigned by this court to handle this appeal, Mr. Newbort told me about two attempts at conversations or conferences between Mr. Peters, Your Honor, and Mr. Newbort.
Okay, so you were at least then aware of the substance of that
Yes,
from Mr. Newbort, I assume?
yes,
And that one of the things presumably you learned was that there was a claim by Mr. Peters that his appellate counsel, Mr. Krinsky, had not actually prepared a brief, but had simply taken a little bit that his prior appellate counsel had prepared, and then a large portion that he himself had prepared, and filed that. You were aware of that?
I was not aware of that. I was informed by Mr. Newbort that Mr. Krinsky did prepare a brief, that Mr. Peters contributed to the brief, and I believe, if I'm correct, Your Honor, I believe the question that you had.
And did you see that in his quorum nobis petition, that question?
Yes, I did.
Okay. Then would it be, going back to Judge Trautman's question, is it fair to say that I think it's 7 issues you've raised here, if I've counted them right. None of them is an issue that Mr. Peters raised in his quorum nobis petition?
Your Honor, in my brief and my argument before this court, in terms of the ineffective assistance of appellate counsel, I raised some of the issues that were raised by Mr. Krinsky. However, I believe...
I'm sorry, I'm not asking about Mr. Krinsky.
Regarding Mr. Peters, yes, Your Honor,
We have a quorum nobis petition that Mr. Krinsky had nothing to do with filing, that Mr. Peters filed on his own. With me so far?
Yes, I am.
And that has, I think, if I've counted correctly, 6 issues raised in it. You have, I think, raised 7 issues, and I don't see any overlap between those. Is that right?
One of the issues that Mr. Peters raised in his quorum nobis dealt with ineffective assistance of trial counsel. That was one issue, and that was the issue I intended on focusing on today, was the ineffective assistance of appellate counsel not fully briefing and dealing with the issue of ineffective assistance of trial counsel.
I'm sorry, counsel, I'm confused at this point. I guess my question is, in the original quorum nobis petition that was decided, was the issue of ineffective appellate counsel raised?
I believe so, Your Honor. Your Honor, I expanded on some of the issues, or at least the issue of ineffective assistance of trial counsel, in terms of the ineffective assistance of appellate counsel. And I took the position as follows. Throughout the trial, and I had the opportunity, with the help of Mr. Newbort, to get portions of the trial as well as the clerk of the court, to review the entire transcript. Throughout the transcript, as was handled by defense counsel at the time of the homicide trial, there were numerous issues that were of an evidentiary nature that came up during the trial before Justice Feldman back in 2004. One of the issues dealt with a Molyneux issue in which...
But it's not a direct appeal now.
No, it's not a direct appeal, Your
So
Honor.
you're limited to what's considered on the quorum nobis. So we're back to the Chief Judge's question, where's the overlap between what you've briefed and what was actually raised on the quorum nobis and decided by the appellate division?
Actually, Your Honor, there's very little that I raised in my brief
Yes.
that Mr. Peters raised. Mr. Peters raised different issues under ineffective assistance of
Okay,
trial counsel.
is there anything that he raised that you've raised? Let me try it that way.
I don't believe so, Your Honor.
And you read his quorum nobis petition, Mr. Peters' quorum nobis petition, not as alleging that his appellate counsel failed to raise deficiencies of his trial counsel, but rather than on his quorum nobis, he was just complaining about trial counsel, not appellate counsel's failure to raise trial counsel's errors.
Your Honor, I think the simplest way of focusing and answering that question is, Your Honor granted leave on the issue of ineffective assistance of appellate counsel, which is what I focused on. I raised other issues other than what was raised in his direct appeal and which Mr. Peters himself raised on his pro se quorum nobis proceeding. The main issue...
Well, aren't those new issues better resolved in a new quorum nobis in front of the appellate division?
No, Your Honor, they were not.
Why?
Why?
Because there was one, for example, which I think is a glaring omission, was the preservation issues. There were the issues of failure to request limiting instructions with
No,
certain
counsel,
pieces.
the question wasn't whether they were raised in the prior quorum nobis. The question was, wouldn't they be better raised in a new quorum nobis application to the appellate division? Because otherwise, and I think there's a sense here, that there may not be anything for us to review.
Your Honor, I agree, and according to the law and according to the CPL, they can be raised in a new quorum nobis proceeding before the appellate division.
So why wouldn't you do that? Or what allows you to come here and ask us to ignore the fact that that didn't happen?
Without giving a glib answer, Your Honor, Chief Judge Wilson granted leave in this case, and that's why I'm here.
Yes, but you're not arguing any of the issues that were actually before the appellate division that the chief judge granted on.
No, because the issue of,
I think no is kind of the answer.
the
but-
issue of, before the appellate division, there was no issue of ineffective assistance of appellate counsel, which I believe, as the chief judge pointed out in his conferences with Mr. Peters and with Mr. Newbort, those were the issues that were flushed out. And that was the issue that was flushed out in the order in which you granted leave, and then subsequently in which I was appointed. So what I decided to do, and based upon my experience in terms of trial work, is to review the entire record in this case and to focus on the issue of the ineffective assistance of trial counsel. Similarly, as Your Honor pointed out, could be made in the appellate division, but again, my marching orders, for lack of a better term, were to file the brief here as I was appointed by the court in terms of doing that. And the issues, if I may, which I believe are significant, which are compared to other matters and other cases in which this court is...
Well, you may have believed that your client might have done a better job as a pro se and raised some other issues, but the grant is on one quorum nobis and what the appellate division decides on, right?
That's true.
That's the marching orders, if I can put it that way.
That's true. But I also point out, Your Honor, and I also point out, Judge Rivera, that I believe the CPL and the sections which were cited grant the court the authority to hear additional issues. I believe was what was cited in this case, which I certainly think is distinguishable, is the Feliciano case, in which the appellate division originally thought that the quorum nobis proceeding that was brought before it was a motion to re-argue. This court then stated, after hearing the Feliciano case, that that was actually a quorum nobis case, and then sent the case back to the appellate division for further proceedings based upon the appellate division's erroneous ruling on that case. And I believe it's section 470, CPL section 470.05, and then another section of the CPL which grants this court the appellate authority to hear the ineffective assistance of appellate counsel, and I believe the statute specifically deals with the issue of appellate counsel in the CPL section dealing with the powers of the Court of Appeals.
Thank you.
Thank you, Judge.
May it please the court, my name is Solomon Newbort and I represent the people. I would just like to maybe clarify some facts so to avoid some of the confusion.
What happened?
What happened was that perhaps there might have been a little bit of an oversight on my part in my leave letter. What happened was the defendant filed a quorum nobis petition raising certain claims of ineffective assistance of appellate counsel, faulting trial counsel on several grounds, saying that appellate counsel should have raised these other claims. That motion was denied. Then the defendant put in a leave letter, and then the defendant moved to re-argue in the appellate division. After he moved to re-argue in the appellate division, he raised for the first time a claim that Mr. Krinsky didn't write the brief, or that Mr. Krinsky was just doing pro forma work and he wasn't responding.
I think that's in his original petition, I think.
I believe that that was only in the motion to re-argue, and this was a new claim in his motion to re-argue. That's my recollection of what happened. And so when Your Honor granted leave to appeal, Your Honor, you granted leave to appeal from the original quorum nobis application, but not from the motion to re-argue. And the motion to re-argue, the appellate division didn't grant, but then on re-argument deny. It just denied re-argument, which was an unappealable decision, and so leave couldn't even be granted from that decision. And so it was just an unappealable decision. And I think because there was a stay and everything got very
They bring
confusing.
a new quorum nobis on the issues that were raised in the re-argument motion?
In the motion to re-argue, the defendant raised all the claims that he raised in his initial quorum nobis application, plus this new claim that Mr.
So
Krinsky
the
wasn't.
new claim, could that be raised in a new quorum nobis petition?
That new claim could be raised in a new quorum nobis. He can raise all his claims. He can raise the claims that he raised on this appeal in a new quorum nobis.
But there's nothing to prevent him from bringing that to the court of first instance where the alleged ineffective assistance of appellate counsel occurred, i.e. the appellate division.
Correct, and the appellate division allows it all the time. I have defendants who have filed 5, 6, 7 petitions for quorum nobis. They just keep bringing it, and the appellate division entertains them all. They deny them all, but they entertain every one of them. There's nothing preventing a defendant from bringing seriatim petitions for quorum nobis.
And he could bring seriatim requests for leave to appeal to this court, right?
That's correct, Your Honor. And so he can bring all of these claims, again, in the appellate division, the court of first instance, as this court in D'Alessandro actually did.
I just want to be clear on this, what he can do. So he gets a CLA grant on the issues raised in his quorum. Those issues are not briefed to us.
Correct.
Let's just hypothetically say we find nothing persuasive. You're saying he could then file another quorum raising the exact same issues that he was granted on and seek another CLA?
Correct, and there's 3 reasons. This court in
And
D'Alessandro gave...
another lawyer would brief again?
Well, he brought it pro se the first time, and so he can bring it pro se
No,
again.
I'm talking, well, he has a lawyer now. I'm talking about if he got granted again. How many times can he keep trying to get a CLA on the same thing that's going nowhere?
He can bring the same, he can file the brief that he got in this court, in the appellate division, and that'll be the court of first instance, and now
That
he's
would
even-
not be the same issues. I'm talking about the issues that were granted, raised on the quorum.
I'm sorry.
I'm sorry. My apologies. Let me try it again. I'm talking about the issues that were raised in the quorum that he then sought a CLA on, which the chief judge granted, which are not, counsel said, he didn't brief in his brief. You're saying he could go get another quorum on those exact same issues that the CLA was already granted on, but were not briefed.
So he can bring another quorum nobis on what he raised in the motion to re-argue, what he raised in this court for the first time, and he actually has the benefit of counsel now because
Not what he raised in this court for the first time, the issues that he raised in the quorum that were not briefed to us at all this time.
Right, as I was saying, in D'Alessandro, this court gave 3 reasons for why that shouldn't be permitted. And they said, this court said, we note that a claim of ineffective assistance of counsel should be heard and decided in the court where the allegedly deficient representation occurred, so it should go there first. Then this court said a second reason. Further, the proffered approach would deprive defendants, the defendant in this case wanted to have this court decide issues that weren't raised in the quorum nobis, or that were raised in the quorum nobis but were dismissed and so were never decided by the appellate division, saying it would deprive the defendants of the potential to have the merits of their claims addressed twice, once by the appellate division, and if unsuccessful, once by this court on a motion to leave to appeal. Then this court gave a third reason. Finally, we are not in the habit of reviewing the merits of an argument in the first instance without the benefit of the lower court's reasoned analysis.
So in a new quorum nobis, he could raise, as I understand you, both the arguments that were initially before the appellate division but not briefed to us, as well as the arguments that he raised in the motion to re-argue that re-argument was denied.
Correct. And he can even raise the original claims that he raised in his first quorum nobis that he raised initially. There's nothing preventing a defendant from bringing the same claims again and
You can
again.
raise whatever you want in a quorum nobis, you can put whatever you want in a quorum nobis, but it seems to me it's unusual to have a case come up to our court where we grant leave on an issue, the party doesn't brief it, we decide against that party then, and then they can come back and litigate that same issue again. That doesn't seem like a good system to me.
Well, this court wouldn't be actually reaching the decision. That would be just saying that we're not going to reach this court would say the defendant is not raising the claims that he raised below, and so we're not going to reach it because it would be better for the defendant to raise it in the court of first instance.
He raised them already. He's just not raising them here. Some issues he did raise, just not being argued here.
There's no overlap in any of the arguments that the defendant raised in his initial quorum nobis application where he claimed ineffective assistance of appellate counsel and the arguments that he's raising in this court in support of his claim of ineffective assistance of appellate counsel.
No, that's right. The point is whether or not the grant, the CLA grant, on the issues that were raised in the quorum nobis that are now not presented to us, he should be able to go and just do another quorum nobis because his lawyer didn't raise it to us. I'm not understanding the argument, is my problem.
Well, the claims that he raised in his initial quorum nobis for which there was a leave grant,
Yes.
this court could reach it, but the defendant has abandoned those claims, and so for that reason, this court shouldn't reach those claims.
So if it's abandoned, can he then file another quorum nobis on those same issues? Because I thought that's what you were saying. I may have misunderstood you.
He, in theory, again, there's no statutory
Well, would he be
prohibition of a
stopped
defendant raising the same claim twice
So there's-
on a quorum
There's
nobis.
no consequence that flows from the abandonment, you're saying?
There is no adverse
In the quorum nobis
consequence from the
context.
abandonment. He can raise the claims again in the appellate division. The appellate division might say, just like we rejected those claims the first time on their merits, we'll reject them again on their merits. At some point, if a defendant keeps bringing a quorum nobis application, the court might say there's an abuse of process and might bar the defendant from bringing any further ones without an attorney, which sometimes happens where a defendant brings 7, 8, 9, 10, 440
Counsel.
motions or quorum nobis
Counsel,
applications.
Here, there was initial quorum nobis wherein the defendant made certain claims with respect to how his case was handled. The appellate division reviewed, correct?
Correct.
As to those claims.
Correct.
Then when they denied, he sought re-argument.
Correct.
On re-argument, he raised something different from that which was put in the original quorum nobis.
Correct.
Is that correct?
Correct.
But that which was denied, the merits of that had never been reviewed by the appellate division.
That's correct, because they denied the defendant's
It was-
motion to re-argue.
And the denial of re-argument was not appealed.
The defendant did seek leave to appeal, but there was no leave grant from that motion to re-argue.
But there are two separate avenues that were going on
There was
with
two-
respect to reviews.
Correct. So the defendant was simultaneously seeking motion to re-argue in the appellate division while he had a leave application pending before this court. Then he supplemented his leave application after the motion to re-argue was denied, asking this court to consider also the claims raised in the motion to re-argue, but that wasn't properly before this court because it was a motion to re-argue that was denied, and that's not an appealable decision. But that, again, the defendant could, in theory, go back to the appellate division and bring a new quorum nobis. He can raise whatever claims he
Based
wants.
on the issues that he raised in the re-argument that were never arguably
Correct.
reviewed by the appellate division. And then if his claim is that the appellate division improperly denied that, he could then perhaps seek leave.
That's correct, Your
I
Honor.
guess my question was why on the issues raised in the quorum nobis that the grant is on, that the lawyer has decided not to raise, why should that fall? Are you saying that's the client who has waived them?
Well, if a defendant raised the claim in the appellate division and then his attorney didn't raise it in the Court of Appeals, and so it's abandoned, the appellate
That
division.
all falls on the client, because this is their representative. Am I just understanding you correctly?
Again, all I could say is that the appellate division is not limited to hearing new claims on a
No, I'm
quorum
talking
nobis.
about in this court.
I'm-
In
I'm
this
s-
court.
in this court?
Yes.
Well, the defendant didn't raise them in this court, so this court doesn't have it before he's abandoned it, then this court is not, and I believe that there are decisions from this court that this court is not going to review a claim that's been abandoned in this court. But that, again, doesn't prevent him from raising it in the appellate division.
Let me
He
ask
just
you
can't
this.
raise it in this.
Let's say that the defendant wishes to raise an ineffective assistance of counsel claim regarding the lawyer who has briefed to us on the quorum. Where will he file that?
In the appellate division.
And the appellate division will determine whether or not they were ineffective in their appearance before us, correct?
If there was an ineffective assistance of appellate counsel in
that's
the
their
appellate
argument.
division, not in this court, of
No,
course,
but
it's not
that's
a
what I'm
court.
asking about. That's my question. If he raises a claim that counsel was ineffective before us for failing to raise any of his claims that he was granted leave on, where would that be considered? Where is that going?
There is no such claim because the defendant is not entitled to counsel on a quorum nobis application at all. So it's only, a defendant can have a claim of ineffective assistance of counsel where he's entitled to counsel, but he's not entitled to counsel on a quorum nobis application. And so the mere fact that this court granted the defendant counsel.
So we may grant, or we may appoint counsel who conducts themselves in a manner that's ineffective?
In this court?
Yes, and the individual has no recourse.
Correct, because he wasn't entitled to counsel in the first place. You can only, a defendant is
Not entitled to any
entitled to
counsel, so you
effective
can get one
counsel.
that's completely deficient. I'm not ruling on you, sir, but I'm just theoretically, please. Deficient, and they have no recourse. I just want to be clear about that. Your position is they could raise the issues again. I
A
understand.
claim of ineffective assistance of counsel presupposes a right to have counsel in the first place. If the defendant doesn't have a right to counsel, he can't complain about counsel that he didn't have a right to have. So on a 440 motion, a defendant doesn't have a right to counsel, so if he had ineffective assistance on a 440, he's out of luck. It's as if he brought a pro se.
This court appointed gratuitously.
Well, not gratuitously, it's hopefully counsel is going to be more effective than a layperson, but that doesn't mean that if
When
the
you
attorney.
say no right to counsel on a quorum nobis, do you mean no right to have counsel appointed for you? Or do you mean that if you have your own paid counsel, hold on, if you have your own paid counsel, the court can say, no, we're not letting that person appear? Which of those do you mean?
I meant the former. The defendant is not entitled to have counsel appointed on his or her behalf to represent him on a quorum nobis application. Surely an attorney can file a quorum nobis application. They do it all the time, and the courts entertain it all the time. But that's very different from saying that the defendant has a constitutional right or even a statutory right to have counsel represent him or her on a quorum nobis application. If you don't have that right, you don't have the right to claim that you had deficient counsel. You can have somebody come on your behalf, but then you just don't have a right to complain about what they did or didn't do on that procedure or
So is it your
proceeding.
position that there's nothing reviewable for us here?
Well, when I say, let me qualify that. There's no statute on what the parameters are for review of a quorum nobis application. All that the CPL says is that the Court of Appeals may review a denial of a quorum nobis application, but unlike direct appeals, there's no statutory framework. However, this court in D'Alessandro laid out its own framework saying it's not appropriate for this court to review claims that weren't raised in the appellate division, and that's better, if it would be better to send it back to the appellate division for them to review whatever claims. And in this case, that was a case where there was a wrongful denial of a quorum nobis application. In this case, the defendant would just have to bring a new quorum nobis application. It wouldn't be remittal. It would just be a new quorum nobis application. Thank you, Your Honor.
Your Honor, the sections that I was referring to is CPL Section 450.90 and CPL Section 470.35(1). And it states that upon an appeal to the Court of Appeals from an order of an intermediate appellate court affirming a judgment, sentence, or order of a criminal court, the Court of Appeals may consider any questions of law, including alleged error or defect in the criminal court proceedings, whether such issue was raised or not. In response to the inquiries of the court, I don't think it's that clear that this court cannot entertain the,
So we can say that the appellate division was wrong to deny a quorum nobis application based on claims that they did not review. Is that what you're saying?
no, I'm not, Your Honor. What I'm saying is that this court can, on its own, review a question of law, which is the ineffective assistance of appellate counsel, whether or not the appellate division has decided or not the issue of ineffective assistance of appellate counsel. And in response to Judge Rivera's question about abandonment, if I may address those very briefly. The question presented in this particular case dealt with ineffective assistance of appellate counsel. It did not deal with singular issues of what took place during the trial. For example, a suppression hearing in which the gun that was ultimately recovered from a vehicle accident was introduced against Mr. Peters at trial. Those issues are not part of the ineffective assistance of appellate counsel because the trial court and the hearing court in this case ruled that it was a close call in terms of the admission of the gun. The court had some issues with the testimony of the police officer, for example, but the court did not find that the officer was incredible. So raising issues such as that singularly is not what this court was looking for. Everything was raised under a rubric, under a cosmopolitan approach of the ineffective assistance of counsel.
Of appellate counsel.
Of appellate counsel, excuse me.
But counsel, if what you're saying is true, isn't that the functional equivalent of saying you can bring a quorum nobis application in the Court of Appeals for ineffective assistance of appellate counsel in the first instance, since it doesn't require review by any lower court?
I submit that the statutes are unclear on that. The statute, there's no grounded decision one way or the other in terms of that issue.
Well, what I can tell you for a fact is we don't get any that I'm aware of direct quorum nobis applications to the Court of Appeals. So something sounds amiss.
I'm not saying direct quorum nobis. This is a denial of a quorum nobis, and my submission to the court, Your Honor, is the fact that this court on its own can decide the ineffective assistance of appellate counsel. I'm not saying that an individual has a right to just petition the court while bypassing the appellate division.
But you could raise whatever issues you want once you get leave granted on the issues you raised below.
Not issues whatever you want, Your Honor. I respectfully disagree. It's issues that is presented. In this particular case.
Presented where?
It was presented by the chief judge in terms of the question of ineffective assistance of appellate counsel.
I don't get to present issues.
That was excuse me, Your Honor, the gist of the conferences, I believe, that Your Honor alluded to between Mr. Newport and Mr. Peters. Again, I was not privy to that, and it was upon my conversations with Mr. Newport that...
Did you talk to Mr. Peters about the substance of the conference?
I did, Your Honor. He was incarcerated at the time. It was somewhat difficult. I did discuss with Mr. Peters throughout.
I'm not asking the substance of what
No,
you
of
discussed.
course, but I have been in constant written and oral communication with Mr. Peters and with his family, who's in the court today, to observe the oral arguments.
Thank you.
Thank you, Judge. Thank you.